for my favor because she's not a victim. And I hate saying that because she gets up here and she reads this letter. That letter, she almost didn't even look down. She had it memorized. She's good at it. She's been great at it. But not everything that I've done is true. I didn't do all these things.
This case takes a shocking turn before it even begins. A man accused of blackmail, a victim with a decade of alleged abuse, and a courtroom where the truth feels anything but clear. But here's the twist. What happens when the accused doesn't just deny the charges, but claims the victim is lying, manipulating, and not a victim at all? Stay with us, because this case spirals into a tense battle of credibility, emotion, and a final ruling that no one saw coming.
Making it a level 6 person felony, dismissed the second count. At time of sentencing, Your Honor, the parties would follow the presumption.
Right out of the gate, we're seeing a strategic legal move here, a plea deal that significantly reduces the stakes. Instead of facing multiple charges, the defendant agrees to plead no contest to attempted blackmail, with other counts dismissed. Now here's what's important. In no contest, he means he's not admitting guilt outright, but he's accepting conviction. That's often done to avoid harsher penalties at trial. But here's the question. If the allegations are as serious as they sound, is this deal too lenient? Or is it a calculated move because the prosecution's case might not be airtight?
Asked that this case run concurrent to his Sedgwick County case. I don't believe there's any legal reason why that cannot be done. He's already serving a significant prison time as a result of the Sedgwick County matter.
Ms. Norris, is that your understanding of will be recommended at the time of sentencing?
Yes, Your Honor, that is correct.
All right, so it's not your thought that he was being supervised on the other case at the time this one occurred? It's fairly old fact scenario.
And Your Honor, no, the Sedgwick County case in this case happened around the same time frame. And I don't believe that he was on supervision for, well, certainly not that case, but any other that I'm aware of.
All right, and Mr. White, you've heard the plea agreement that's been announced, is that correct?
Yes, Your Honor.
And you wish to enter a no contest plea to amended count 1, attempted blackmail, in exchange for a dismissal of counts 2 and 3?
Yes, Your Honor.
A level 6 felony carries a sentencing range of between 17 months and 46 months in prison. Do you understand that?
Yes, sir.
Keeping in mind the matters we have discussed, is it still your wish to plead no contest and accept conviction for this level 6 person felony?
Yes, Your Honor.
All right, Ms. Norris, could you please provide a fact?
This moment is critical. The judge carefully confirms that the defendant understands everything: the charges, the sentencing range, and the consequences. That's standard procedure, but it also locks the defendant in. Once this plea is accepted, there's no turning back. And notice the sentencing range mentioned, 17 to 46 months. That range becomes extremely important later. So keep this in mind. Even though both sides are recommending a lower sentence, the judge is not bound by that agreement. And that opens the door for a major twist down the line.
Prior to, and defendant did repeatedly message her and was threatening to disseminate videos and photographs of a sexual nature, and basically was threatening to send those to specific friends and family members if she did not make contact. And at that time, there was a PFA in effect.
Now this is where the case becomes deeply serious. The prosecution lays out the factual basis: repeated messaging, threats to release intimate content, and an active protection order being violated. That combination, blackmail plus a prior relationship plus a protection order, is what elevates this beyond a simple harassment case. It introduces elements of control and coercion. But here's the big question for you. Do these actions clearly prove malicious intent, or could there be more context missing from this narrative?
I further find that you understand the rights you're giving up by pleading no contest, and that the facts of the case are sufficient for a finding of guilt. I further find your decision to plead no contest has been freely and voluntarily given after having received the advice of counsel. I will therefore find you guilty of amended count 1, attempted blackmail, a level 6 person felony. Ms. Norris, is the state dismissing counts 2 and 3 at this time?
Yes, Your Honor, the state would move to dismiss at this point the counts
All
2
right.
and 3.
I am going to order a pre-sentence investigation report. We need to schedule a sentencing hearing at least 8 weeks out.
Judge, March 23rd at 1:15.
All right, we'll set a sentencing date for March 23rd at 1:15. All right, Mr. White, do you have any questions?
No, sir. Merry Christmas.
All right, you as well. Good afternoon. All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled State of Kansas versus Joshua Aaron White. All right, we're scheduled today for a sentencing hearing.
The court know that the victim is present and does wish to address the court as part of the sentencing process.
Of last year, there was a plea of no contest to one count of attempted blackmail, a level 6 person felony. The court did order a PSI at that time. I have received the PSI indicating a criminal history score of A. Ms. Norris, is there any objection to the criminal history score?
No, Your Honor, that is as we expected.
All right, and Mr. Watts, any objection to the criminal history score?
No, Your Honor.
This is a presumptive prison case. There are no special rules that apply. I don't see any departure motions have been filed. Is that correct, counsel?
That's correct, Your Honor. The recommendations, the parties would recommend this run concurrent with his current time. I will tell the court his current out date is in 2045.
State would be recommending the mitigated box.
Here's something that might surprise viewers. The prosecution and defense are actually agreeing on the sentence. Both sides recommend 40 months on the lower end of the sentencing grid and to run it concurrently with an existing sentence. That's huge. It means the defendant wouldn't necessarily serve extra time beyond what he's already facing. But here's where things get interesting. Judges don't have to follow these recommendations. So the real question becomes, will the judge accept this agreement, or is something about this case pushing toward a harsher outcome?
Yeah, I have a victim impact statement I'd like to read.
All right, go ahead.
Okay. So, Your Honor, my name is Christy Hannon, and I am here today as the victim in this case. For more than a decade, my life was shaped by fear, control, manipulation, and abuse. What happened was not just moments in time. It was years of emotional trauma, stalking, intimidation, and blackmail that affected every part of my life. I lived in constant fear for my safety and for the safety of my children. I questioned my worth, my strength, and even my ability to survive. The abuse did not end when the relationship ended. The stalking, the threats, and attempts to control me continued stealing my peace, my sense of security, and years of my life that I can never get back. Because of this abuse, I have carried anxiety, trauma, and emotional scars that no one can see. I have had to rebuild my life piece by piece, learning how to feel safe again, how to trust again, and how to believe in my own voice again. I have lived with the lasting impact of choices that I did not make but was forced to endure. But today I'm not here only as just a victim. I'm here as a survivor. I have fought to protect my children. I fought to rebuild my life. I fought to become the woman I am today. I am strong, resilient, and determined that this abuse would not define the rest of my story. What I want the court to understand is that domestic violence, along with blackmail and stalking, is not just physical harm. It is power and control. It is a fear that follows you long after visible wounds are gone. It is years of healing from damage that should have never happened, and accountability matters, not just for me, but for every victim who's afraid to speak up. Your Honor, I ask the court to consider the seriousness of these actions and the lasting impact they have had on my life when determining sentencing. Blackmail against an abuse victim is especially cruel. It is another form of power and control that keeps a survivor trapped in fear and silence. It takes someone who is already wounded and threatens their safety, reputation, and stability in order to maintain dominance over them. The emotional damage of living under that kind of threat is profound and long-lasting. No survivor should ever have to live in fear of being manipulated or exposed simply for trying to escape their abuser. Because of the severity and lasting impact of these crimes, I respectfully ask the court to impose the highest sentence allowed by the law. This request is not made out of hatred or revenge, but out of the need for justice and accountability and protection, both for myself and for others who could be harmed in the future. I am sure that you have reviewed the defendant's PSI report, and you can see this is not just an isolated incident. The defendant has a long criminal history and up until recently was always given minimum accountability for his crimes by the criminal justice system. A strong sentence, a clear message that domestic violence, stalking, and blackmail will be taken seriously and will not be tolerated needs to happen. As a victim, when you listen to the plea and sentencing negotiations recommended by the DA and the defense counsel, it feels as if the victim doesn't matter when the recommendation is the lower end of the sentencing grid. Victims receive a lifelong emotional sentence that needs to be taken into consideration. And these are not private matters. They are crimes that change lives forever, and a minimum sentence on the sentencing grid is not appropriate.
That was a powerful and emotional statement. Moments like this can heavily influence sentencing. The victim isn't just describing isolated incidents. She's painting a picture of years of fear, control, and psychological trauma. In court, this kind of testimony isn't just about emotion. It helps the judge understand the impact of the crime beyond the legal definition. But here's the tension. While the victim is asking for the maximum sentence, the legal agreement suggests something much lower. So who does the judge ultimately side with? The negotiated deal or the emotional weight of this testimony?
A long time. A long time. She's been in love with me since she was a child, 13-year-old child. We've been dating, having sex since that time. And she comes on here and acts like she said it herself, revenge. And this is exactly what she's already piled years on me. And we've been battling with these same cases since 2019, and she stacked them high. She went to Sedgwick County and read the same report. And they gave me the sentence because I went to trial to stand up for my rights because I'm an innocent person. I didn't do some of these things. Some of them I did. Some of these I did, but not the ones that carry the most weight. And I'm in here fighting myself. And now I have no jail credit for this case. And I understand that. It doesn't make it right, but I've been battling this same case, this same stuff since 2019. She waits until I get charged in Sedgwick County and then stacks these on top of me too. If I beat these, I'm going to do 4 years from today. If I beat these other charges in Sedgwick County, I still got to do 40 months. 40 months whenever I beat the Sedgwick County stuff, because I have a lot of things for my favor, because she's not a victim. And I hate saying that because she gets up here and she reads this letter. That letter, she almost didn't even look down. She had it memorized. She's good at it. She's been great at it. But not everything that I've done is true. I didn't do all these things. This stuff here, this is basically, if you go read my Sedgwick County case and this.
And here it is, the moment that changes the tone of the entire case. The defendant doesn't just defend himself. He goes on the offensive. He accuses the victim of lying, calls her statement rehearsed, and even admits to some wrongdoing while denying the most serious claims. That's a risky move in court. Judges pay close attention to accountability, and statements like this can either humanize a defendant or completely damage their credibility. So ask yourself, does this sound like someone telling the truth or someone digging a deeper hole?
Out of revenge, out of being sad, from me being with another woman, and this other woman's in this court today. She's watching, thank God. But I asked for some kind of leniency, some kind of time, and they're going to start my time today, even though I've been battling this for years, since 2019, and I don't want to take what she says and act like I don't understand who she is, because I know her very well and she knows me very well. I'm sorry that she feels so much hatred towards me and revenge to just get here and talk like this. And she's very believable. You know, it's sad. I'm here, she's there. And I never in a million years would think I would be somewhere where I'm at for something I didn't do, but here I am. And now I'm getting piled on again. I guess you asked me if I had one thing to say. I would love to say, I apologize for all the bad things that me and her went through, for her to feel so much hatred and want revenge and want these things from me and say that she's this horrible victim and she had to keep her kids. I raised her children. Her children grew up to be good kids because of me. Her kids were awful when I came around, and I'm not want to talk about the children, but the way that she was as a parent, she would be awful, awful. I mean, she smoked cigarettes in her house with her children, and I didn't allow that around my kids when they came over. She was just, and that's minimal. That's minimal. Picking. We can do this all day. But here she is filing charges on me, and they're sticking. But I'd love to apologize to the courts for this all going through this, and it's on the time's on me, not her. This has nothing to
This is the defendant's final chance to influence the court, and he shifts toward asking for leniency. He talks about his time in prison, the conditions, and how long he's been dealing with these cases. But here's the reality. Judges often look for genuine remorse and responsibility. And while he does apologize in parts, he continues to blame the victim throughout. That contradiction can be critical, because in sentencing, it's not just about what you say. It's about whether the court believes you truly accept responsibility.
all the charges, but did you read the facts of these things? And it's like, how, but I guess maybe I shouldn't talk because I have a lot of built up time to think here. You know what I mean? It's all I got here. It's all I can do is think. And I look around, I wake up and I live in a bathroom with another man. And I know that's not your guys' issues, but she's piled it on enough for me. And I don't feel 40 months is fair. I really don't. But then again, if you don't like the plea and you give me more, please don't do that. But I would love some time credit. And I know I'm not probably going to get that. That's what I'm asking is maybe a little time because I've been in Sedgwick County Jail from 2021 until now, battling the same stuff. I mean, it's basically just changed 20 miles from Sedgwick County on Maine to Butler County on Maine or wherever you guys are at. But I'm sorry. Thank you. And that's all I have.
All right, thank you, Mr. White. All right, Mr. White, for the primary offense of attempted blackmail, a level 6 person felony with your criminal history score of A, I'm going to sentence you to the aggravated term of 46 months with the Department of Corrections. I understand the plea agreement anticipated 40 months, but I don't think this situation warrants a mitigated sentence. In fact, warrants the aggravated sentence. So that's what the court is imposing. You are eligible.
And just like that, twist. Despite both sides recommending a 40-month sentence, the judge goes with the maximum, 46 months. That decision sends a clear message. The court did not believe this was a case deserving leniency. The combination of the defendant's criminal history, the nature of the offense, and possibly his courtroom statements all played a role. This case highlights something crucial. Plea deals can shape expectations, but they don't guarantee outcomes. And in emotionally charged cases like this, the judge's discretion can completely change everything.
If you can't afford an attorney to do an appeal, one will be appointed for you. Ms. Norris, are there any sentencing related orders that the court has not addressed?
I don't believe so, Your Honor.
Mr. Watts?
No, Your Honor.
As the court stated earlier, there are no special rules that apply in this case. All right, if there's nothing further, the court will be in